We welcome you to the, thank you. Welcome you to the final setting of the Seventh Court of Appeals on September 17th, 2025. We have before today another criminal case. We'll go on call docket. You are experienced appellate lawyers, so you know how you act, so to speak. We ask questions, you answer. You have been informed of the time periods involved, so we will not go over those. And I'll just go on call the docket and you just let me know that you're here and we'll start there. Okay?
You can actually tell this group, thank you for coming to Lubbock.
I was about to write a note, Amarillo.
You know, once you get old, they never let you forget you get old. Prior case, I kept saying, thank you for coming to Lubbock. And that's what happens. You get kind of stuck in Lubbock. But the case we have today, or the last case we have for this morning is 07-24-00299-CR. Nathaniel Nyauser, excuse me if I pronounced that wrong, I'm sure I'll be corrected, versus the state of Texas for the appellant. And did I mess up the name? Nyauser. Okay, thank you. And for the state?
Jeffrey Ford for the state.
Thank you. You have the floor.
Good morning. May it please the court. Jessica Groff for Appellant Nathaniel Nyauser. Your honors, from beginning to end, Mr. Nyauser was denied a fair trial, and there are several reasons for this court to reverse. And while I'm happy to answer the court's questions about any of them, for purposes of my limited time today, I plan to focus on issues 1 and 3 in the briefs. First, that in voir dire, the district court overruled numerous valid challenges for cause and erroneously curtailed the defense's ability to ask proper questions. And second, the district court abused its discretion when it made the unprecedented decision that the state met the high bar to show an 8-year-old sane witness incompetent to testify. Now, turning to my first point, the trial court abused its discretion in 2 key areas. First, in denying challenges for cause on jurors who could not consider the full range of punishment. And second, in denying challenges for cause for jurors who would consider police officer witnesses to automatically be more credible than others.
What were the proper questions?
Your honors, the proper questions, first on the range of punishment issue.
What was the question asked?
The
Isn't
question,
that what the trial judge was saying is you didn't ask the proper question. You didn't ask it in the right way. What was the question asked and why was that proper, the right way?
The question, it was asked in multiple ways, but essentially we can see on page 251 of the record, defense counsel explained the elements of the offense and then asked, can you consider the full range of punishment, including the lower end? And then as the process went on with a back and forth with the jurors, the defense counsel asked if jurors could foresee a circumstance where they would give meaningful consideration to the full range of punishment. And then on page 255 of the record, in response to a juror's question, defense counsel again clarified, yes, what is required is meaningful consideration of the full range of punishment. And we know that is a proper question based on the CCA's decision, first in Cardenas and in Standifer, that a proper commitment question is one that leads to a valid challenge for cause. And the CCA has held that commitment questions, committing the jurors to the range of punishment, is proper. Now, the CCA has also given kind of one important guide range on what a juror has to be able to do to consider the full range of punishment. And that's in Johnson versus State, where the CCA said that a juror must be able to accept that for the offense in question, the minimum legal punishment will be appropriate in some circumstances and the maximum will be appropriate in some circumstances. That is what defense counsel was trying to find out with these questions to the jury. But the trial court held that these were improper commitment questions. That's not accurate based on CCA precedent, again, in Cardenas, Standifer, and Johnson.
What was the second question again that was asked? Can you consider the full range of punishment, including the lower end, was the first one, I think.
Correct. And then counsel asked if the jurors could foresee a circumstance or a set of circumstances where the lower end of the range of punishment would be appropriate.
That seems closer to a commitment question.
It would be if the defense counsel asked the jury to commit to a specific fact. Give me a fact where you would give or circumstance where you would give the minimum. That's not what defense counsel did. Defense counsel asked the jury to consider the elements of the offense, and then
Can you foresee a set of circumstances? Sounds like give me a fact that would support getting the lower end.
it could be, but again, it could also be asking for a hypothetical, which would be an appropriate question to give the jury. Now, we're not asking facts about this case. We're not giving anything other than the elements of the offense and asking, can you foresee a set of circumstances? And I want to compare that to the questions that both the state and the trial court asked the jury on this very issue. The state on volume 3, pages 108 to 109 said, so without knowing any facts, you just have to come up with a scenario in your mind where you could give meaningful consideration to the bottom and then the top. The court did the same thing, pages 303 and 304 of volume 3. Can you envision a scenario where you could give meaningful consideration to, or is there a scenario where you could consider the appropriate punishment being the minimum?
Did the denier respond to that? That was asked to the denier?
The court was asking an individual when individuals were called up for questioning. And yes, the juror responded that they could consider the full range of punishment to that. When the state asked, some jurors highlighted that they could not, particularly when probation was at issue, but it was also just a broad question to the denier. But what all of these
What were the questions that were asked that caused the judge to call those individual prospective jurors up to undergo further questions?
It's not clear from the record what happened after the broad panel was questioned. The parties went up, each side had a list of jurors they intended to call up, and the court also had a list of questions. The court didn't identify why, but when this particular juror came up, and I searched the record trying to figure out what that juror said, and I couldn't find a clear answer, but the judge called several up on different issues, including the range of punishment question.
Were there other questions that were not objected to or were allowed by the court that dealt with the range of punishment?
None of these questions were objected to. What happened is
Or that were allowed by the court
all
that dealt with range of punishment?
the court allowed all of the questions that were asked to the panel in the broad panel questioning. What the court did was when the defense had a list of jurors who answered no to the defense's questions on range of punishment and asked either that they be struck for cause or called up for individual questioning, then the trial court said, no, I don't think the questions you were asking to the broad panel were proper. Those were improper commitment questions, so I will not be calling
Yet
those.
some were called up.
Correct, but not from the defense's list. But what the defense was attempting to get at with these questions is
We know that it's not from the defense's list,
the defense listed out their numbers
and that's in the record.
yes. And the defense listed out on both issues, the range of punishment and the law enforcement credibility, all of the jurors that they wanted called up for questioning. And the trial court denied that because the trial court determined these were improper commitment questions. But again, based on Cardenas and Standifer, these were proper commitment questions, committing the jury to give meaningful consideration to the full range of punishment.
Suppose we agree with you that the court should not have prevented those questions. What is next is the step in the analysis? Is it an automatic remand or what do we do under those circumstances?
So in this circumstance, there's kind of an interesting analysis that's a mix of preservation and harmless error. But what has to happen is the defense has to ask for those jurors to be questioned. That would be denied. Then the defense would exhaust their peremptory strikes and ask for more. Once that is denied, then the defense identifies objectionable jurors that were sat on the jury that they could not strike because the trial court denied those challenges for cause and denied the additional questioning. So under either cause challenge.
Okay, let's say you're right. There was error. Is there a harm analysis?
That is the harm analysis. The CCA has described it as odd as both sort of a preservation and harm analysis. But if the defense meets those steps, right, exhaust the
We
strike.
presume there's harm.
Yes, then that shows there is harm. And that is, the defense did that in this case, took each step, identified 2 objectionable jurors who sat on the jury that the defense was not able to strike because the trial court denied those cause challenges denied peremptory strikes, denied additional.
So I want to make sure I understood what you were saying, because I may have misunderstood. As for the question, can you consider the full range of punishment, including the lower end? The judge says you shouldn't go forward and ask, inquire about that, or sustains the defense's objection. The way to preserve that question for appeal then is to go through your traditional for-cause challenge analysis.
Exactly, yes. The CCA has held that both of those, and I believe that case is, yes, Smith versus State, that explains that the standard for both is the same. Whether the judge is denying valid challenges for cause or denying proper questioning of the jury on a proper issue. Now, looking at the second area of inquiry, where jurors stated that they would always or almost always, right off the bat before hearing a word out of their mouths, consider police officer witnesses more credible than other witnesses. The CCA again gives us important guidelines to determine when a juror has said something that makes them ineligible to serve for witness bias. First, in Jones, the CCA held that a juror who has an extreme or absolute position can be struck for cause. And then in Ladd, the CCA said that jurors that give certain classes of witness a slight edge in terms of credibility, those are not challengeable. So we have this spectrum for the CCA. On one end, a slight edge, on the other end, extreme or absolute. Now, jurors who said that they would almost always or always believe police officers because they are police officers, that's not a slight edge in terms of credibility. That is on the extreme end of the question. Again, what the trial court did here was say that that was not a proper question to ask. Instead, the trial court said they would only be challengeable for cause if they were always going to believe police officers over other witnesses. But again, we have a proper question from defense counsel on page 73 of volume 3. Defense counsel asked who would not be able to start off police officers at the same level of credibility as someone else, always or almost always. Defense counsel repeated this question, repeatedly asked the jurors if they understood the question and needed more clarification, and still numerous jurors said, yes, I would always or almost always believe a police officer before I hear a word out of their mouth just from the badge and the gun. Those jurors should have been struck for cause. But even if the trial court was correct and that a juror would only be able to be struck for cause if they always believed police officers, the trial court then erroneously denied defense counsel the ability to individually question those jurors to make that distinction. Then you said always or almost always, which is it? The defense laid out the CCA precedent to the trial court, explaining why the question was proper and enough to strike. But even if not, the defense counsel asked for time to do more questioning. And in fact, again, the trial court called someone up, one person, asked them, are you always going to believe police officers? And that person said yes, and was struck for cause. But the trial court did not allow defense counsel to call up their list of witnesses or their list of potential jurors who had answered affirmatively in the broad panel questioning that they would always or almost always. So under either.
What was the question asked by the state?
Yes, it was, Your Honor.
No, what was?
What was the question asked by the state? That was. The most important thing to remember about witnesses is that you have to start them off at the same level when they testify. That means whether it's a cop, the Pope, a prostitute. Can everyone agree to do that? Is there anyone here who feels like that because of their relationship with law enforcement or trust in law enforcement, that they would not be able to start them off as the same level as credibility as someone else? A couple of jurors answered yes. Those were the ones who were married or good friends with police officers. And so those individuals were struck for cause. But when the defense asked that question, more people came forward at that point and said, yes, I will always or almost always believe a cop before I hear a word out of their mouth. The trial court.
Was there some overlap between?
I can tell you based on the numbers. Yes, so there was a couple, so that the 3 individuals responded yes to the state. I believe 12 individuals responded yes to the defense. So there was some overlap, but there were still a considerable number of additional jurors who weren't struck for cause. And then the trial court did not allow defense counsel to further question them and get that always, rather than almost always, that the trial court believed was necessary. I do want to briefly touch on error preservation for this issue. The state has argued that the defense did not preserve error on the issue of limitation of questioning of Verdire. I want to make sure it's clear that they are not arguing that we didn't preserve error on the cause challenges, just on the right to ask additional questions. And what the state has argued is that because defense counsel did not get on the record and say, Judge, had you allowed me to question these jurors, I would have asked this specific question, that it's not preserved for review. But CCA in Langston said that no magic words are required for error preservation. And this court in Mack versus State on this very issue said that really the question is, can the Court of Appeals tell from the record whether the party was precluded from asking proper questions? And the answer here is yes. We can see that from the back and forth between the trial court and defense counsel when the trial court denied defense counsel and told them that their questions were improper. On the issue of range of punishment, volume 3, pages 312 to 13, defense counsel requested individual Verdire on whether the jurors could give meaningful consideration to the full range of punishment. And this was after a back and forth where defense counsel, citing a CCA case LAD, said that its questions were proper commitment questions. And again, on witness credibility, page 281, defense counsel said, I would like to further question them on the law enforcement question. Again, this was after the back and forth between defense counsel and the court about whether it had to be always or almost always. So based on the record itself, the narrow topics that were clear to the trial court, this court can review whether defense counsel was precluded from asking proper questions of the jury. Now, turning to my second point, under the
Counsel, with regard to double jeopardy, was the injury to the child at the time of trial the same injury to the child at the time of the event? Or did it grow over time?
There was no evidence put on that it grew over time. So the injury that the state was required to prove was serious mental deficiency, impairment, or injury to JN. But what the state failed to do to prove both counts 4 and 5 was to put on any evidence of an increased injury based on lack of medical treatment. Not one witness testified that JN suffered greater harm because appellant did not take him to the hospital. But the CCA in Villanueva versus State says that's what required. You can charge 2 counts of injury to a child, one based on act, one based on omission, but you have to prove a distinct harm. This was flagged to the state pre-trial. The defense raised the double jeopardy issue. It was flagged again in the charge conference, but the state simply never put on any evidence of any increased injury. It was all kind of a complex trauma resulting in these mental health diagnoses.
Is there any evidence of the injury at the time of the event, other than the bruisings, things along that line, the physical injury? Was there any evidence of the mental injury?
There was
mental
evidence.
Condition of the child?
There was evidence put on of his diagnoses. So he was diagnosed with ADHD, kind of a dysregulation mood disorder, and his struggles there. He is seeing, multiple.
At a time of trial, or was that time of the events?
That's the time of trial. That since the time he was taken from appellant, he was put into, of course, given medical treatment and put into these therapies.
Is there any evidence that the conditions experienced or present at the time of trial had to have developed over time?
No, Your Honor. The evidence put on was simply JN's diagnoses, the struggles that he is undergoing, but none of the state's witnesses, none of the experts testified that any of that had been exacerbated over time, or most importantly, that had appellant gotten him medical treatment sooner, that the effects would have been mitigated. The classic example of these cases is going to be a head injury where the parent doesn't take the kid to the hospital and then they develop permanent brain damage. There is a clear causation there to that greater harm. That is completely absent from the record in this case. Now, briefly returning to the competency question about whether JN was competent to testify, what the trial court did here was confuse mental health and credibility issues with.
Counsel, with regard to confrontation, what was the purpose of videoing? Is there any evidence in the record to indicate what the purpose of videoing the events was?
So because the person who took the video, the co-defendant Erica Gregory, took the fifth, nobody was able to ask her why she did that. But what it appears from the video itself is she is secretly recording, probably with her phone, appellant, his wife, his mother-in-law, JN. Nobody knew that they were being videoed. And Erica Gregory is asking JN, who touched you? Who touched your wee-wee? Over and over and over again. And there is no reason for her to ask that question other than to be creating evidence against appellant, especially considering that multiple people had recently called the police on her for her abuse of appellant.
Do we look at, when we look at whether testimony, statements are testimonial under Crawford, do we look at the intent of the speaker, or do we look at the intent of the other people who may have recorded it and taking that into account?
If I see I'm running low on time, if I may answer your question. So what the this court said in Coronado versus State is that we look at the surrounding circumstances and whether they objectively indicate that the primary purpose of the interview or interrogation is to prove past facts or evidence potentially relevant to later criminal prosecution.
I suspect the focus would be on the person who's recording.
Correct. And to be fair, it could be on the speaker, but when we're dealing with a child, obviously a child is almost never going to be making a statement for purposes of a prosecution they don't understand. But here, what we have is all the circumstances surrounding this video, making it clear that what Erica Gregory was doing was creating evidence to use it against appellant because people had accused her of abusing appellant, a person with intellectual disability.
Does it have to be use in a criminal setting or just use in a blackmail setting or some other advantage?
Your Honor, I just want to point out, I see that I'm out of time.
Yeah, it's fine.
Yes.
That's fine.
I could not find a clear answer to that question. And I looked because I understand that this is a really bizarre fact pattern and really unusual. But I would say that it comes to the same end. If you're using it for blackmail, blackmail for what? For criminal prosecution. So the objective purpose here was to create some sort of evidence to use against appellant, potentially for a criminal prosecution. I don't know that she realized at the time she was creating evidence against herself.
Well, we see it sometimes in a family law setting. There may be a custody fight or something, and one parent's trying to prove that the other parent is unfit. They're using it in the context of a civil case, but it also could be used for criminal purposes. And so I think what the chief was asking, like, at what point do you have to envision that it's actually going to be used as testimony?
And in this case, I don't know that we could ever answer that because Erica Gregory can assert the fifth. But what this court has said is that the standard is an objective one. The circumstances objectively indicate that the primary purpose is potentially relevant to later criminal prosecution.
Did she take the fifth related to this case?
Yes. Yes, the defense tried to call her in this case.
Thank you, Counsel.
Thank you, Your Honors.
May it please the court,
Counsel.
counsel. Your Honors, I would like to thank the court.
Double jeopardy.
Excuse me?
Double jeopardy.
Yes, Your
Talk
Honor.
about that first, if you don't mind.
Yes, Your Honor, of course.
Act, omission, you don't disagree, or do you disagree that for the omission, there has to be some additional injury?
I would agree that the injury has to be made greater by later denying the child
What
a
is the
victim medical
evidence of
treatment.
the greater injury here?
Your Honors, we have the testimony of Dr. Hansen in particular. Dr. Hansen's testimony, a combination of Dr. Hansen's testimony and the defendant's own statements. There, in his own words, his failure to seek medical treatment. I'm sorry, Your Honor, back up a little bit. In his April 16th video and his own interview statements show that he was aware of the abuse of JN. He denied having caused any of the abuse, but he acknowledged that he was aware of the abuse and failed to seek any medical treatment for him.
I'll use the term exacerbated.
Yes, Your Honor.
The omission exacerbated. Okay, I understand that he didn't take any effort to get medical care for how was that omission, how did that omission exacerbate the injuries to the child? Where is the evidence, like I was asking opposing counsel, that over time, because there was no medical attention, these conditions at the time of trial developed, things along that line? Where's that evidence?
That evidence is primarily through testimony of Dr. Hansen.
What is that evidence?
Her evidence, her testimony was about emotional and psychological abuse caused by the physical abuse seen on the video, and that the incident that caused the abuse and what was seen on the video could be described as toxic stress events there, and that the failure and that the ongoing abuse there would have was what caused the trauma and stress.
The ongoing abuse or the act, correct?
The act and the it would be the act and the omission is what caused the trauma and stressor related.
Is there indication that
disorders.
she is talking about abuse within the framework of omission, or is she talking about the ongoing abuse within the framework of the acts?
I believe she's talking about all of it together. I don't believe that she specifically parsed out acts from omissions there, but she was talking about all of it. That all the ongoing abuse, both the acts and the omissions, caused the trauma and stressor related disorders.
Were there any predicate type questions that would allow the hearer to understand she is talking about both acts and omissions? Or are they just to assume that?
I don't believe that she directly said the words that the omission caused greater mental deficiency. I don't believe that those exact words are present, but I do believe that the context of her testimony would be sufficient to show that.
How does a parent's been accused of a crime. Parent says, I didn't perform the act. I didn't perform the illegal act. What is the parent supposed to do under those circumstances to avoid this omission charge at that point? I mean, is it sufficient to say, I didn't do it, but I'm going to take you to the emergency room now to be checked out because I need to discharge my obligations? I'm trying to understand. It seems like under your argument, every case involving alleged parental abuse of a child can also have an omission charge brought in unless they're taking the child to the emergency room immediately after it occurs.
There must still be party liability, Your Honor. The person must still encourage, direct aid, or attempt to aid the commission of the offense. Here, had the defendant simply been aware of abuse there without anything further, there may be a separate charge, but wouldn't necessarily, for example, it would be a failure to report the commission of an offense charge, for example, there, but wouldn't necessarily be an injury by omission offense. But we have the video here, the April 16th video, showing that he was not only aware of the abuse there because he was one of the people, he's one of the people committing the abuse there. We see it directly on the video. But then after being aware and participating in the abuse, both as a principal and as a party, then he did nothing about it there. He did not take the victim to the emergency room afterwards. So therefore, both as a principal and as a party, he's guilty of both act and omission theories.
But
yes, Your Honor.
Opposing counsel gave a brain injury example. I'm gonna go simpler than that. Let's just go say a parent cuts a child, okay, cuts him with a knife. All right. That's the act, there's an injury, the cut. Then fails to get medical treatment and they develop sepsis. That's a separate injury that developed from not taking and seeking medical care.
Absolutely, Your Honor.
Here we have the ongoing abuse that Dr. Hansen testifies about. But how can you point to us in the record to separate the injury from the omission versus an injury from the act? It seems like it's all together, it's ongoing. And she testifies about ongoing abuse.
I do agree that the abuse was ongoing, yeah, Your Honor, absolutely, and that's why there's such a broad range of time put in the indictment. There from the time period of JN's birth all the way up until May 6th. There, that entire range is included in there because specifically because this was ongoing abuse here, both by act and by omission.
Then we'd have, that gets back to my question, we're
Yes,
gonna have to accept that she was talking about both, and that somehow, when she was talking ongoing abuse caused these injuries, she was implicitly saying, yes, by not going and getting medical attention, these injuries were developing as well, that were not existent at the time of the acts, commission of the acts.
I
Is-
I don't believe that we'd have to implicitly believe that she was saying that. I believe that we can look at our own words there that discusses the diagnoses there, the diagnoses of trauma and stress related disorder.
Let me ask you
there.
this, is there
Yes, Your Honor.
testimony in the record that indicates that if they immediately took the child to the doctor at the time of the act, or that was recorded on the iPads, the child would not have suffered from the conditions the child was suffering at the time of trial?
Had they, I don't believe that there is any evidence of that there with regards to the April 16th video. Certainly is evidence that took the.
That was just one example, but of
Yes,
any event, is there any evidence saying that after this event, if you took the child to seek medical care or some type of care, child will not be suffering the conditions, the maladies the child's suffering now?
I am unaware of any portion of the record that directly states what Your Honor is saying.
I guess in a variation of what the chief was just asking about, certainly the experience of being sexually assaulted is a traumatic act in and of itself.
Absolutely.
There's no testimony or other evidence that experience, that traumatic experience was somehow made worse because they did not receive medical treatment at the time or thereafter.
I'm sorry, just clarify what Your Honor is saying. Are you saying, is there any direct testimony in the record to state
Right, other than Dr. Hansen's general testimony about the ongoing nature, there's no other testimony that the conditions, that anything else about the child were made worse as a result of the failure to receive treatment, separate and apart from the traumatic experience itself?
Other than Dr. Hansen's testimony, I'm unaware of any direct evidence of what Your Honor is saying.
Can you spend a little time talking about appellant's issue number 3 and 4? To me, I'll just be candid with you. I'm a little troubled by some of these issues and the way that they play, because we're looking at one of the key issues under the confrontation clause is the ability to confront, your accuser, and also the ability for the jury to see that person testify live so they can test whether the person is telling the truth or not telling the truth. On the one hand, the judge said that the victim was not competent to testify. Presumably, they didn't know the ability to tell the truth from a lie. But on the other hand, the video comes in that allowed the jury to assess the truthfulness of the person making the statement. To me, there seems to be a conflict there for confrontation clause purposes. Why not allow the alleged victim to take the stand and allow the jury to assess for themselves whether the testimony has any veracity?
Yeah, Your Honor, and I'll parse that into two separate responses here. The first part of that is about whether someone who is incompetent can provide a statement, such as a side utterance statement or an existing mental or physical ability statement. And the U.S. Supreme Court in Ohio v. Clark directly addressed that particular issue. They're saying that in any confrontation clause case, the individual who provided out-of-court statement is not available as an in-court witness, but but the testimony is admissible under exception to the hearsay rules and is probative of the defendant's guilt. The fact that the witness is unavailable because of a different rule of evidence does not change our analysis. In other words, what they're saying there is, yes, even though a witness may be incompetent as to testify and therefore cannot be questioned about the statements there, that is a separate issue from a confrontation issue and whether a statement is testimonial in issue. Now, with regards to the second portion of what Your Honor was asking there, in any case, a court has to determine where an issue has been raised. Of course, the court has to determine whether a witness is competent to stand trial. We cannot be putting incompetent witnesses on the stand there, and that is very much what happened in this case. Here we had a pretrial hearing there where we had the testimony of JN's adoptive mother.
How long was that hearing?
I'm unaware of that. How long?
How long was the trial judge's interview of the child?
It was a few minutes. I think
Somebody
approximately
indicated
6.
20. I thought I read 20 or something.
I thought it was like 6.
I thought it was 6.
Was it 6?
I'm thinking that it was 6, but I'll let the record speak for itself if it was lengthier. But because the trial court, once an issue was raised as to the incompetency of the witness there, the trial court had an obligation to determine whether JN actually was competent to testify as a witness there. And through the questioning of JN's adoptive mother, through the questioning of Dr. Beth Robinson, and the omission of psychological records from both parties, trial court properly determined that JN was incompetent to testify because he did not have the capacity to recollect the events or the capacity to narrate the events. JN's psychological records and Dr. Robinson's testimony show that JN had significant executive functioning difficulties and that it would be difficult for JN to recollect events that occurred before the age of 4 years old due to his age when the events occurred and due to delayed development of the hippocampus.
Right, but the net effect of both of those rulings by the trial court is that that the members of the jury only saw the video where the alleged victim said dad did it, and they didn't, and the defense didn't have an opportunity to test that further.
I agree that they were unable to call JN as a witness here. But in addition to the Ohio v. Clark case I just mentioned, also mentioned a Court of Criminal Appeals case, Ortega v. State. It's a 1973 Court of Criminal Appeals case that said that even though the victim was found to be incompetent as a witness, her spontaneous declaration to her mother shortly after the offense was admissible. And that's a situation that we have here. We have those statements on the video. They're properly admitted over a hearsay and confrontation objection here based on excited utterance and then existing mental or physical condition grounds. And
Does impact on the witness factor into the decisions of competency? Because wasn't there some testimony that if you make this child testify, it's going to cause worse injury to the child?
I don't believe that is one of the factors to be considered.
So it's just the ability to perceive, recall, and relate, basically. Perceive,
Yes.
recall, and relate.
Yes, Your Honor.
Okay.
And I, with my existing, with the rest of my time here, I'll briefly talk about the confrontation issue.
Oh, I guess one
Dr.
brief question about the record.
Yes, sir.
The judge's interaction with the child, the 6-minute time or whatever it was that on the record?
It was, Your Honor. It's outside the presence of the parties. I believe it's on a Zoom call, but it was recorded on the record. With regards to the confrontation issue here, a statement does not fall within the confrontation clause unless primary purpose is testimonial. When applying the primary purpose test, factors courts should consider include the existence of an ongoing emergency, the formality and purpose of the questioning, and the statements and actions of both the declarant and interrogators. During the questioning of opposing counsel, the court was asking about the purpose of the recording. I can't get into the mind of people who would do the horrendous abuse that was done in this case. So I cannot definitively state what the purpose of the recording was, but I can talk about.
To what extent is the fact that the iPad, which contained the video, was pawned, contradict the allegation that the purpose of the recording was to garner testimonial evidence. Is it, am I off? Are those non sequiturs, or does the pawning show now it wasn't for purposes of testimony?
In your honor, I agree with everything that you're saying here. In fact, you made my argument for me. I believe the actions speak louder than words, and the fact that not only did she not turn the recording over to law enforcement there when she had every opportunity to on May 6th, there it says she held on to the recording for 2 additional years, or at least almost 2 additional years, and then pawned the iPad. Her and Jessica Adams pawned the iPad that contained the recording on it. Shows that this was not made for purposes of later disclosure of law enforcement.
Standard of review, de novo or abuse of discretion, do you recall?
The standard review with regards to the admission of evidence is abuse of discretion. Whether it's testimonial or not is de novo standard, your honor.
Okay.
And of course, there are also the statements contained by JN himself on the recording there, because in considering whether a statement is testimonial or not, you consider the statements and actions of both the declarant and the interrogators. Erica Gregory's actions after recording are inconsistent with it being used for purposes of later prosecution. And JN's age, combined with the ongoing situation in which the statements were made, certainly belie any claim that his statements contained in the video were testimonial in nature. In Ohio v.
Wait, before
Yes,
we
Your
run out of time, switch
Yes, Your
gears. First issue, while there, opposing counsel was indicating that the trial court was asking the same questions of the members that it prevented the defendant from asking. Were they the same questions? Did they diverge?
Your Honor, thank you for asking that there, because I did want to briefly address that. The question that was prevented from being asked, or not does prevent from being asked, but that the trial court said he's not calling everybody up based on that particular questioning, was, can you foresee a set of circumstances in which that would be improper? During which the minimum range cannot be given. In questioning of one of the veneer members, the trial court did ask a similar question, which was, can you foresee a circumstance where you could give serious consideration to that? Standing alone, that may be seen as parroting what the defense had previously said, but I believe that the judge recognized that he was asking an improper question himself there, because he later corrected himself during the questioning of other veneer members, specifically on pages 300, 303 to 305, 307 to 308, and 309 to 311. The judge changed the foresee a set of circumstances inquiry. Instead, he asked whether the jurors could give meaningful consideration to the full range of punishment there. So I don't believe that the trial judge was abusing his discretion simply because he asked that one question, since he corrected himself for the questioning of the other members. And Your Honors, I see I'm out of time.
Thank you, counsel.
Thank you, Your Honor.
But and if we have by questions to take you over the time period, don't ask for opportunity to answer, just go on and answer. Okay.
Sure, Your Honor.
Thank you.
2 points on rebuttal. First, on the competency issue, the state said that Dr. Hansen testified at the competency hearing that JN would not be able to recall or narrate events because he has executive functioning issues and couldn't remember events before the age of 4. And that's why he's incompetent to testify. Now, leaving aside that Dr. Hansen never evaluated JN, we know from the record, from the testimony of JN's adoptive mother, Shelby Amon, that JN did remember events from before the age of 4, because he told her, she said in a nonchalant way, that he remembered his biological mother beating him with a shoe rack, and that he remembered his biological grandmother biting him.
Did she ever say he remembered his biological dad doing anything?
No, she said he claimed to have no memory of his dad. He would just say, no dad.
Well,
And-
isn't that important to the equation then?
Because that goes to a credibility issue. It doesn't go to competency. What the CCA said in Watson is the standard under that prong is, does he have the capacity to recall relevant events? He does. First of all, the time period that's relevant here is massive because the indictment was birthed to the day he was taken away. But we know that he has the capacity to recall relevant events in that time period because he does. And he told his adoptive mother that. So this is also, I think, a unique case in that JN never made an outcry against appellant, right? So this isn't like the numerous other cases where a victim is called to testify about a specific instance, a specific event from the defendant, and then they give that testimony. This is different because of the number of co-defendants, the range, and the fact that there was no outcry against appellant. But every court has considered this issue, has made it clear that a witness doesn't have to remember everything, right? In Allen versus State, the 14th court, the victim witness didn't remember the day he was shot, the whole event, but he testified. In Bradshaw versus State, the Waco Court of Appeals said a child was competent, though she said she did not know and could not remember the offense. So here, what we have is essentially the judge determining, well, you don't remember appellant. Appellant is accused of doing something to you, therefore you are not competent to testify. When in fact, that goes to the defense's very case, that appellant was not the primary abuser. His mother was. That is who JN made statements saying his mother beat him, and also told his foster mother that his mother touched his private parts.
We have witnesses all the time who take the stand who may not remember certain details about a case, or they may get called involuntarily, may not know anything about the case at all. That doesn't render them incompetent. That simply means they don't remember.
Absolutely. And that is something that the jury is allowed to take into account. But that's not what the trial court did here. He misapplied the standard. And moreover, he did it in terms of conflicting the competency to stand trial standard and competency to testify as a witness standard. We can see that what the trial court said was that on page 327, volume 3, JN doesn't understand the nature of court proceedings based on his behavior. That has nothing to do with whether he is competent to testify. JN was hyper. He had a hard time sitting still. We don't, contradict that he has mental health issues.
Can there be implied in a finding there that he doesn't understand the nature of court proceedings and meaning the importance of telling the truth?
It could, except that the trial court explicitly found that JN does know the difference between the truth and a lie. And he asked JN multiple questions to verify that point. So that trial court didn't exclude him as not understanding the truth. He excluded him as being hyper and not remembering a
Being
plan.
hyper, would that, the other activities, moving around, etc., would that relate to the recall or relate portion of the equation, perceive, recall, and relate? That just moving around, you
Right.
can't relate it because it's not paying attention. He goes off here, it goes off there.
I think that is part of what the trial court was saying, but we have to look at what JN actually did. Was he hyper? Yes. Did he get off track sometimes? Yes. Did he answer the judge's questions? Also, yes. He answered the judge to his age. He confirmed through multiple questions that he knows the difference between the truth and a lie. He confirmed that he remembered his biological mother and her name. He was able to answer these basic questions, and he was able to recall relevant events. That is all that is required for the very low standard of competency to testify. But the trial court here really made the unprecedented decision. I can't find a single case like this where an 8-year-old sane witness was found incompetent to testify. And that is what gets us to the level of abuse of discretion.
Time's up, but I'm gonna ask a question. I'd like an answer. With regard to double jeopardy, opposing counsel said that there is testimony, I guess, from the experts saying that ongoing abuse covered both the act and the omission response.
It doesn't, and that is because of the way the state charged this case. Both counts 4 and 5 list the same harm, right? Serious mental deficiency, impairment, or injury. So what the state had to prove was that the acts caused this serious mental impairment or injury, and then the omission made it worse. They didn't do that. They glommed it all together in this sort of complex trauma analysis, and now we're trying to say that they proved 2 separate harms. The record simply doesn't support that.
Thank you, counsel.
Thank you, Your Honors.
The case is submitted and you're excused to go, and we will be in recess. And thank you for traveling from Lubbock. How's that? Okay.